Unchangeable God, that's who you are. Unchangeable, that's who you are. Unchangeable God, that's who you are. Summer, autumn, winter, spring, you still the same. Morning, noon, and evening, you still the same. That's the God I know and I serve, the God that never changes. That's the God I know and I serve, the God of good times. That's the God I know and I serve, the God that never changes. That's the God I know and I serve, the God of good times. Yesterday, tomorrow, and today, every day, you're still the same. Yesterday, tomorrow, and today, every day, you're still the same. That's the God I know and I serve, the God that never changes. That's the God I know and I serve, the God of good times. Yes, I know. Yes, I know. Yes, I know. You're still the same. Yes, I know. Yes, I know. Yes, I know. You're still the same. That's the God I know and I serve, the God that never changes. That's the God I know and I serve, the God of good times. That's the God I know and I serve, the God that never changes. That's the God I know and I serve, the God of good times.
You'll be fine.
I don't have a choice. I have to be fine.
Manini, as I was saying, on my profile, you can just leave out the second paragraph.
I have done that already, sir.
Okay.
Yeah,
Are
it was.
are you doing profiles again today?
I am, yeah. Apparently, it's a needed thing. Because remember, some people who were not here last time might be
Yeah.
new, and they just need to know what's happening. You guys look handsome and beautiful, by the way.
It's so
Oh,
hot.
wow.
It is.
It's so hot. I can't even find my glasses. I think I'm not sure whether it's part of the fanning.
It's easy.
So yeah, but it's fine.
Also, but right. At least you don't have to read much, right?
Yeah.
So I couldn't get to the office today. I was like, hey, Nami, let me do things in the comfort of my home.
Why not?
You know? Yeah. Today I'm actually very I don't know. It's like I'm going to be on stage. I'm not
Yeah.
sure what's happening. Hi, Muruti.
Hello, 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 hello.
What are you doing?
It's time now to start. I think we can switch on all our cameras. Manina, are you able to switch on your camera?
My camera's on.
No, we can't see you. Oh, it's on. Yes, we can see you. Asanda?
Yes, I'm on.
Everyone is on.
No. Oh, Oh, okay. All right. Okay, we're starting, ne? We're about to start. Before giving to Manini, let me just do the official welcoming first.
Yes, sir.
We welcome everybody to our afternoon program. It is the Wills and Last Testament, preparing our last legacy. This is a program that we started off when we closed off our camp meeting, where we concentrated on how to draft wills, the importance of it, and how relevant it is in today's world. We are happy that you've been able to join us. The reason why we also chose today, it is because as of tomorrow, the National Wills Week is beginning, where you're able to see attorneys, where you're able to see lawyers, and I know that some banks are able to also offer that service to us. So it is important that we as a church promote, because we are also part of the global society, and we also promote that we should be able to do things in a rightful way as good as God's stewards, and then we prepare our lasting legacy, not only for ourselves but also for our kids. That is a Christian responsibility. With those words said, thank you for joining us. We know today we're using the platform that has been offered to us by the SID. We truly thank you, Abu Tembi and the team from the SID. Karabo, yeah, our IT guy is the one who's also assisting us in managing everything here. The last word from me after welcoming you, it is that one of our participants is not able to join us. Usis Nomfundo Matonsela, she was supposed to be joining us, but she did send an apology on Wednesday, on Thursday, that she's not able to join us for today. So we'll be continuing with the panelists that we had also previously, and our host is Sis Manini, who's going to be taking it from here. As I give it to her, I will just ask us just to close our eyes, and then we pray together. Let's just close our eyes as we pray together. God, our Father, we thank you so much for the afternoon program that you've given to us. We thank you that we're able to empower ourselves with the knowledge and the wisdom that is required. Lord, as we do your work, may we do it in a rightful way, and may your people benefit from what we do. In Jesus Christ we pray, amen. Thank you so much. Sis Manini, I think let me give it over to you, and then you take it from me then. Thank you.
Thank you very much. A happy Sabbath to Mfundisi and our panelists and all the participants that are here on the Zoom meeting, on Facebook and on YouTube, just the entire community. Happy Sabbath and welcome to our program. It's actually the second session for those who don't know. We had the first one on the 3rd, when was it? 3rd of this month, right? Yes, 3rd of October. Yes, so we had the first session on the 3rd of October, and there was what we call popular demand. People were excited and they just wanted to know more about wills, testaments, and all the information that comes with it. So today, my name is Manini Bitumelo Liputu, by the way, and I have two amazing people here with me. Mr. Thato Mashishi and Miss Asanda. I like her to pronounce her surname. Asanda, can you pronounce your surname for me?
It's Dipakube.
Asanda Dipakube. Just says it so nicely. Asanda Dipakube. To me, it sounds like, you know, some poetry, something. And we obviously will be missing Nomfundo Matonsela, who's not here with us today. We thank Mfundisi, the SID, and the church at large for the opportunity for us to give knowledge to the church and those that are outside of the church. Okay, so to begin this Mfundisi Vulile in prayer, I will just give a short introduction to those who were not here on the 3rd of September. Our topic is wills. Wills and testaments, preparing a lasting legacy. So our panelists saw it fit that we call it preparing a lasting legacy, because this is something that we do not know, especially in our Black community. This is what I'm saying, right? So what we will be doing is talking about wills, the definitions, recapping on what we spoke about on the 3rd, so that everyone can catch up on what we're talking about today. And since it is, Mfundisi mentioned that it's National Wills Week, right? We are asking everyone to please take the opportunity to go to organizations, to go to right, attorneys, and just find the help that they need. Yes, Asanda, Thato?
Yes.
So if we want them, let's just take the opportunity. Do you want to say something on that? Because I don't have much information on it.
Okay, so on the Law Society website, there is a list of attorneys that will, and firms, law firms that will be participating in the National Wills Week. So for every province from Eastern Cape, you name them. Every province, every town, you've got attorneys that will be participating and that will be assisting with drafting of wills and everything regarding estates.
Okay.
Yeah, I think it's also important to mention that the service will be offered at no cost to whoever wants to make use of that. So it's going to be free of charge.
Yeah.
So you can just approach any law firm that may be closest to you and ask to make the appointment for your will to be drafted. So at no cost to you.
Okay, personally, I love supporting businesses, whether it's Black owned or white owned, but I would take this opportunity because it's free. And I'm sure everyone
Yeah.
has time. I take leave from work, find nannies for your kids for the day or whichever day you choose to just go and take this opportunity. Things like these never happen. It just doesn't come for free. Attorneys are expensive, advocates are expensive, legal things are very expensive. So if you have the opportunity and time, please find the time. Okay, so what I'm going to do right now is to read a disclaimer. And after reading the disclaimer, I'm going to read the case studies that we will be using. The reason why we have a disclaimer to our audience is because we do not want to be pinned down. We do not want Thato's name to be mentioned in the near future or Asanda's name to be mentioned in the near future to say, I came here because Asanda said on the 24th of October. So whatever we're going to disclaim now is just to give you information and guidance to say what the two of them will be saying today is their own opinion. So it is not tied to any organization. It is not tied to any law fraternity. It is opinion of their knowledge and their practice, right? Okay, so the disclaimer goes as follows. Please be advised that the views expressed by our panelists are their own and not those of their employers, associated organizations, and affiliations. In no way should their views be construed to constitute legal advice. Qualified legal practitioners should be approached in this regard. I'll read it again. Please be advised that the views expressed by our panelists are their own and not of their employers, associate organizations, and affiliations. In no way should their views be construed to constitute legal advice. Qualified legal practitioners should be approached in this regard. And this week is the perfect week that you go to qualified legal advisors. And because it is better for us to have a story and a background of case studies, I'm just going to mention 2 case studies. But before that, I am very rude. I need to introduce our panelists. For those that were not part of this session on the 3rd of October, I will introduce our panelists so that you understand when they speak, their background and where they're coming from and who exactly they are, should you want to contact them. So I'll start with ladies. It's ladies first, right? Thato, you still believe in that? In ladies first? Right? Okay.
I'm fine with that.
Yes. Okay, so you're still a traditional man. So we'll start with the lady. Okay, so Asanda Dipakube is a practicing advocate at the Johannesburg Society of Advocates, a member of Group 1 Advocates, an accredited mediator on panel of mediators for conflict dynamics and arbitration, Foundation of South Africa. She holds an LLB, LLM in criminal justice and labor law at the Nelson Mandela Metropolitan University, and an LLM, Extractive Industries Law in Africa from the University of Pretoria. A postgrad certificate in advanced construction law from the University of Pretoria. Her preferred areas of practice are construction law, administrative law, commercial litigation, labor law, oil and gas law, and mining law. She's a deaconess and a Sabbath school superintendent at Moy Kloof SDA Church. Ibandla Maliti, amen.
Amen.
And then we have our gentleman. And his profile goes as follows. Thato Mashishi is an admitted attorney of the High Court in South Africa. He holds a Bachelor of Laws from the Northwest University, a Master of Laws in Corporate Law from the University of Pretoria, and he is currently pursuing a postgrad diploma in taxation at the University of Witwatersrand. He is a legal consultant at one of the global big firms where is focused on data protection and privacy law, financial services law, mergers and acquisitions, and general corporate and commercial law. Then there's a huge paragraph that I'm going to leave out, Bazalwane, because I will not finish, and I'll just skip to where he's from. Thato Mashishi is the youth leader at Calvin on Athol Seventh-day Adventist Church. If the church wants to hear more, I will gladly type it out on Facebook on our live. And they're able to find out more information on Thato. Ibandla Malithi, amen. Okay, amen, Bandla, amen. Okay, so without further ado, I'll just go to the scenarios, the two scenarios we're going to use, and then we're gonna get right into it. So the first scenario, and I humbly ask the audience to just really listen to these scenarios, because all the questions that will come after that in the discussion will stem from this. So scenario number one, we have a lady, Tshepo is a 32-year-old single mother of a minor child. She works for a good organization and receives a good monthly salary. Tshepo lives large. Shopping sprees, luxurious weekend getaways are her lifestyle. Tshepo has considered thinking and planning for her life so her child would be taken secure should anything happen to her. But she decides that that can wait until she is a little older. For now, she will enjoy the years of her youth. In a tragic turn of events, Tshepo dies in a terrible car accident. So that's scenario number one. Number two, Nandi and Dan are married in a community of property. They are proud parents of 3 kids. Dan has a child outside of the marriage. The young couple, with the assistance of an attorney, draw up a will, which is kept safely at the attorney's office. During the COVID pandemic, both Nandi and Dan tested positive, and unfortunately, Dan passed away after being admitted into the ICU. So what we're going to do after this, audience, is to have our panelists just give us a recap in accordance to these two scenarios. Just give us a recap on what we discussed on the 3rd of November. I'm far ahead. On the 3rd of October. So they will both touch on each questions that we had touched on previously, just so we can get people up and running, and then we get into today's session. I don't know if the traditional Mr. Mashishi will have the ladies first going.
I think ladies
that hasn't changed.
Thank you, Thato. Thank you, Manini. Hello, everyone, and welcome to our session 2. So for those who were not with us in the previous session, last session, we really touched firstly on the basics before we could build up on what needs to be done and how a will needs to look like, and all those formalities that one needs to comply with in order for your will to be valid. And the first question that we really dealt with was, what is a last will and testament? Because in formality, that's how it's addressed. You know, when you say a document, it will be written last will and testament. And the explanation really is that it's commonly known as it's a will. So in practice, it's called a will. So even though as a formal document, it's called a last will and testament. So this is a document. It's a legal document that is prepared and put in force in terms of the prescribed law of wherever you are, whether you are in South Africa, concerning the disposition of your assets should anything happen to you. And this is what will be used to control your assets in the event of you dying. And the person that, the person whom the will is about is called a testator. So if I today, for example, in the second case study that Umanini just read, we've got Dan and Nandi, yes. We've got Dan and Nandi. So Dan and Nandi, they have, let's say they have a will, right? So Dan and Nandi will be the testators of the will. Or if Dan alone has a will, then will be the testator. So that is just a legal term that is used to refer to the person of the will, right? So that's what a will is. And last time we made a differentiation between a last will and testament, which is a will, just a will as I just explained now, and a living will, right? And we said that a living will is also a legal document. However, this one is different from your last will and testament. It specifies medical care conditions. For example, in the event of you not being able to make decisions, medical decisions, and something has happened to you, then this is where this will come into effect. So this document will be consulted. This is where you specify whether or not you would like treatment to keep you alive, whether you would like to be kept alive by means of artificial treatment or not, and the type of medication that you would like to receive, whether in the event of you being incapacitated and you are unable to make your own decisions, you are injured or you are sick, do you want to receive blood? Those are just examples, right? Or do you want to be kept on life support? So all of that would then be included in your living will, right? So we've got these, they both wills, but they're different in the sense that the last will and testament deals with your assets when you die, and the living will deals with what needs to happen to you, but you're still alive. And then what else? Yes, and currently in the South African law, we have the law and the rules that prescribe and deal with the last will and testament. In other words, the formal requirements and formalities. But we don't have a law that deals with the formalities of a living will. That is still being a subject matter of a debate in terms of the National Health Amendment Bill, right? Then moving forward, the second question was, why is it important to have a will? I think like Umfundisi said when he introduced the topic for today, you really want to have something in place that will take care of your assets and also your children and your dependents should anything happen to you. Because when you die without a will, then it becomes very, very difficult to divide your assets, to give your children what is due to them, right? And they would suffer. So you want to sapphire a way and you avoid any unintended consequences. So if your children need to benefit, then they benefit. You avoid a situation where your children would actually not get anything from your assets should you die, right? And also you are able to appoint guardians, people who can take care of your children should something happen to you, or you and your wife, if you are married, you die at the same time, who can take care of your minor children. And you're also able to, it actually helps you to keep a record of your assets as well. Because in actual fact, when someone dies, there's always that a search and investigation as to what assets are in place. We might only know of a house and you don't know that your relative has other properties elsewhere. But if there's a will, there's a record of all the assets that your relative who is deceased has, right? And then moving on forward, the formalities. So what are the legal requirements? Or perhaps I should deal with the first scenario. Tshepo, is it Tshepo?
Yes,
Where,
it's Tshepo. Yeah.
yes, the first scenario of Tshepo. Tshepo is 32 years old and she's not married. Tshepo as a child. So many people, we make the mistake of thinking that because you are not married, then you don't have to have a will. Actually, whether you are married or not, and whether you have children or not, it is very important to have a will, because you want to avoid the commotion after your death of family and relatives fighting over your assets. So in the case of Tshepo, who dies without leaving a will because she thought she could deal with it later. So what would happen is that her assets, whatever she has, would then be administered or or yes, I think that's the right word. It would be administered by the Master of the High Court, right? On behalf of the minor child, because as far as we know, the minor child is the only heir or descendant that she has, right? So it would be administered by the Master of the High Court. But then here is where there is a problem. So even though it's administered by the Master of the High Court, somebody has to control the assets. You see, now that's where there is a sting on the tail, because you need to find, there must be a relative somewhere. You see, there's no will, that relative is not named. So it must be a close blood relative. If there's parents, there's a mother, there's brothers, whoever. And you don't have control. So Tshepo won't know how her assets are going to be distributed, or no, actually how her child is going to be taken care of. So it may well be that she has good assets and she has monies and everything saved up, but her child will not be taken care of in the way that she would have hoped and wished that the child should be taken care of. Because look, in as much as the Master of the High Court can control and say, look, how much, this is how much the child will receive for education, but at the end of the day, that money is going to land in the hands of whoever is taking care of the minor. There has to be,
Asanda?
Yes.
Yeah, I think that's a very important point to drive out, that having a will, make sure that whatever your wishes are, those can be fulfilled. If you want, for example, in the instance of Tshepo, if she prefers that the child goes to specific schools and be treated a certain way, she can specify in that will. Because once Tshepo is not around, then whoever is around can do as they please, and that'll be going against the wishes if she had of Tshepo. So I think it's a very important point that you're stressing.
Yeah, no, I totally agree with you, because it happens a lot that let me make an example with Tshepo again. She's worked hard for her money, right? And she has quite good savings, just hypothetically speaking, and you have a minor child, and the money lands, or the control of the estate on behalf of the minor child happens to be in the hands of the aunt, who would be the sister of Tshepo, or whoever. You know, in reality, we have seen it happens a lot, where you have children that have been left by their parents because there's no will. They are not looked after and taken care of in really the way I think the parents would have hoped they should be taken care of. And the money would be there, but the question is, to whom, where does the money end? Who is controlling the money? And so I think thank you, Thato, that's a very important point to emphasize. And really the importance of having a will, once again, you want to prevent those eventualities. You want to prevent something like that happening, right? And so your beneficiaries are able to benefit in the manner that you have specified in your will, right? And then what are the next question that we dealt with, right? Well, what are the legal requirements of a will? Because it's also very important, and it happens a lot in South Africa, and that wills are contested. What do I mean by that? You would draw up a will and you die. After your death, it happens that there's something wrong with your will. It does not comply with the formalities under the South African law. And that is a very big problem, because now it has serious consequences. And the people that you wished would benefit might just not benefit from the will as you had specified in the will. So it's very important. That's why we also emphasized in the beginning that we're doing this because we want to promote the National Wills Week. We want to tell people to go out there and find qualified people to assist them to draft the wills, because you can sit and draft your will at home. Yes, you can do that. But the question is, do you have the expertise to be able to establish and determine whether your will has been drafted in accordance with the formalities that are stated in the relevant acts? And some of us don't, and you're not expected to. You didn't go to school for this. So it's very important that we all go out there and find an attorney or whoever is qualified to draft a will. So what are these formalities? First and foremost, a will has to be in writing, right? So no video recording, no oral wills. If a will is video recorded like this, then it's not valid. If it is oral, I cannot tell Thato that I want my son to inherit everything that I have. It doesn't work. Should I die, he's gonna come and say, Asanda said, but it's not valid. It cannot be carried out. Even though it's my wishes with all intents and purposes, those wishes cannot be carried out because they're not in accordance with the law. So it's important that it's in writing. And number two, the will must be signed by the testator, every page and end of the will, right? And it must also be signed by 2 witnesses or more. The 2 witnesses don't sign at every page, they just sign at the end of the will, right? And also the capacity, your capacity to depose or to prepare a will, you must be 16 years. However, to be a witness, you need to be 14 years in terms of the law of South Africa. And your witnesses, right? Your witnesses, in order for your will to be valid, they must be present when the testator is signing the will. Now, there's a difference between presence when signing and presence when drafting. The witnesses don't have to be present when you're drafting the actual will. They just have to be present when you are signing the will as a testator. And likewise, the testator must also be present when the witnesses are signing the will. In a situation where a person is unable to write, therefore they can't sign, then the person can make an X or there can be a fingerprint there. But in those situations, the will has to be commissioned by a commissioner. I don't want to deal with this question. I think Umanini will deal with it. There was a question around the commissioning and the commissioner.
Yeah.
So when the will is commissioned, I think we'll deal with it later. I don't know if you still remember. I
think it's covered. Yeah, I think it'll be covered later on where somebody posted a question, whether can I go to the police station to have it commissioned? Yeah, I think that's dealt with later on. Yeah.
Yes. So the commissioner must certify that this is the will of the testator, right? And the commissioner must attach a certificate, not just certification. You must also attach a certificate. There's a certificate that is prescribed by the Wills Act, in which a commissioner needs to prepare and attach it to the will itself to say, this is the will of the testator. What happens in the event where the person who has made an X mark or whatever mark as the testator on the will, or has put a fingerprint because they can't sign, dies before the commissioner certifies the identity of the testator. Then if the commissioner has seen or knows the identity, or they had met before and discussed and whatever the situation might be, the commissioner must immediately after the death of the deceased commission the will and attach the certificate and also sign every page of the will. This is the second person who's allowed to sign every page, right, of the will and the end of the will. So that's what happens. And so when you want to make an amendment to a will, same applies. Those formalities will apply. If you want to fix the formal, I think Thato will deal with that, but I'm just dealing with the formalities. That will apply likewise in amendments. The same formalities, everything will apply, right? So what if, the next question that we dealt with was, what if I leave a will at my death, but then the will does not comply with the legal requirements? Simple answer is the will becomes invalid. So the estate of the deceased would then be inherited by his descendants according to the order of succession. And that order of succession, we will deal with it again today, later on in the session, because last time we did not have enough time to deal with the order of succession. So we'll deal with that briefly as well later on in the session. And then another question that we dealt with last time was
Asanda,
who? Yes.
can I just interrupt you there? So you've done question 1, 2, 3, right?
Yeah.
Done 1, 2, 3. Can we just quickly move to Thato to do 6 to 8, and then we leave the 2 questions to put in just in between there, so that our audience can shanganisa the 2 information and see whether I'll ask them, does everyone understand? And we should get yeses on the participants' text, and then we can move along. But you can, those 2 questions, let's say for somewhere in the middle. Is that fine?
Okay, perfect.
Okay. Yes, Thato?
Okay, thanks Manini, and thanks Asanda for a beautiful introduction. I think what you're trying to achieve with this exercise is just to give, for the benefit of people that didn't attend the previous session, we're trying to give you an overview of what we dealt with the previous time. And one of the questions that we dealt with the last time was that, what is the impact of your marital status in the context of your will? Does it have a bearing? Can it have an influence on your will? So essentially what happens is, if you're married in terms of what is called in community of property, which would relate to an instance where there's joint ownership of all the assets and liabilities, which becomes one estate by husband and wife. So they are soon to be one person, one estate. So in that instance, what happens is whoever drafts the will, they could either make a choice of saying, we are husband and wife. In the case of Nandi and Dan, they could say that we want to have a joint will. That's also an option that they could exercise. If it's a joint will, then they'll have the liberty of saying what they want to include in their will and who they want to have as a beneficiary and the like. So that there's that option. However, in an instance where, let's just say Dan as the husband decide that I want to have my own will, which is going to be separate from my wife's, in this case would be Nandi. What that would mean is Dan's estate will only be in relation to his 50% share of the entire estate. Remember, these people are married in community of property, so they have what we call joint ownership of all the assets and liabilities. So his will only be in relation to his 50% shareholding, 50% share that is entitled to. Now, in an instance where we have people that are married out of community of property, in this instance, this means that we have 2 separate estates. Dan has his own estate, Nandi would have his own estate. Then in that context, whoever wants to draft the will, let's just say Nandi decides to have a separate will, then she will be responsible, or that will be in respect of entire estate that will be inclusive of all the assets and liabilities. So the difference is based on the matrimonial regime that will be governing the marriage. If it's in community of property, the will by other spouse will be in respect of the 50% that that spouse would be entitled to. And in an instance where we have people that are married out of community of property, they have the liberty of regulating your entire assets and liabilities in totality. So I think that's the distinction between the 2. And then the other thing that we were meant to touch on last time, but we couldn't because of time, was, let's just say in an instance where Dan, as the husband, has a will, and he decides to, even though he's married to Nandi in community of property, let's just say he has a will, and in terms of his will, he says that I will leave all my assets, basically the remaining estate, I want to give it to my wife Nandi. That's the will. Let's assume that it has complied with all the formalities and everything is, is in order. Now, Dan and Nandi find themselves traveling on a road, and then they get involved in an accident. Let's assume they die at the same time. So usually there's a principle in law which call that for wills, it literally relates around succession. Succession means who benefits from whom and how much and why. So in order for that to happen, there needs to be somebody who's surviving the deceased. So you need to have 2 people. You need to have the survivor, who's the one's going to be inheriting whatever was given by the deceased. So it's very important to establish who died first and who died later. So that's the whole point. And in that situation, it becomes very, very tricky in that we will need to, on an evidence-based, so you'll have obviously qualified professionals that will be coming through, your medical practitioners, and everybody will have the requisite skills and educational background to be able to assist, so that we can determine if Nandi really survived Dan. So if Dan died before Nandi, then the contents of the will would be, easy to carry out. But when you have a situation where, Nandi died before Dan, then that will also change, because then you won't be entitled to inherit based on the contents of the will. So that's something that we also touched on. However, we don't want to get into the details, because they can really get complex with all the intricacies. So we're just going to give a high level so that we understand that it's very important. The will has been prepared. We need to establish who died first and who also died after the other party. So it's very important from that point of view.
Thato, if I could just also add in what you just said. So you mentioned that there's experts that would assist in establishing who died first, where the spouses died simultaneously, right? So another point is that if the experts are not able to establish whether Nandi or Dan died first, then it goes back to what the law would presume. It's called the presumption in terms of the old law in South Africa, which would be that it's going to be presumed that the older spouse in the marriage is the one that died first. So if Dan was older than Nandi, and the experts cannot establish who died first after doing their tests, investigations, and examinations, then it will be presumed that Dan died first and Nandi died after if she's younger, and vice versa.
Yeah, thanks a lot for that, Asanda. I see we're having questions in the chat box. I think we will deal with those later on. So just want to
quick announcement. To all our listeners and our participants, we do note your questions and your comments, and we appreciate them very much. There will be, however, almost at the end of the session, a Q&A session. So we're going to give a good 15 to 30 minutes or around there, time for all your questions. As you write them down, I note them, and our panelists will just go on and give you all the answers that you need. But you can send through. I'm noting them as we're on the session. Yes, Thato.
Thanks a lot, Manine, for that. So another question that we also dealt with the previous time was, what or who is an executor? What role does then an executor play? And what are some of the fees that are applicable to having this person to assume the role of being an executor? So what we emphasized on was that in terms of what we call the governing legislation, this is the law that relates to estate. Now in South Africa, it's called the Administration of Estates Act, which is the law that governs how estates are regulated in the country. So Section 1 defines an executor as any person who is authorized to act under letters of executorship granted or signed and sealed by a master. Now, a master in this context means the master of the High Court, or under an endorsement made under Section 15. Now, Section 15 of this particular legislation deals with endorsement of appointment of assumed executors on letters of executorship. So basically, that's what an executor, this person has to be authorized. So you don't just wake up one day and say, when you find out that, let's just say maybe you're related to Dan and Nandi, that they have died, they have a joint will, and you out of the blue, you're saying now you appoint yourself as the executor. You need to be appointed by the Master of the High Court. We will deal with how that appointment is made and why it's necessary for that appointment to be made. So essentially, the executor is charged with the custody and control of property in respect of the estate upon receipt of letters of executorship. So once you've received authority, you are the custodian of the entire property, all the assets of the deceased estate. You are the one that will have, the responsibility to see to that all the liabilities of the estate are paid, all the assets that needs to be recognized are recognized. So basically you are like the governing, you play an overseeing role over the deceased estate. Now, another thing that the executor can do is that in an instance where the deceased is of the view that there needs to be some money which needs to be released, so that whoever is surviving the deceased needs to be able to fend for themselves. There needs to be certain funds, and this is done before what you call the account is laid for expiation. What we mean by that is once an executor has been appointed, this person has to list all the assets, all the liabilities, invite all the creditors to say that if for example, in the situation of Dan and Nandi, if Dan and Nandi owed you any money, there will be an invitation for you to come forward with the evidence and say, make your claim. So before that happens, the executor can obviously, subject to the approval by the master of the High Court, can say that I can release some money for the family of the deceased or the household, so that there are certain household expenses which could be taken care of. So that's another role that can be played by the executor. And another is in a situation where the executor believes that there might be someone who's withholding either certain information or vital documentation from the executor, which is very important in the context of the administration of the estate of the deceased. What the executor can do in that context, he or she can simply approach the magistrate court with competent jurisdiction and apply for a warrant, which would allow for the executor to basically effect a search and seize of documentation which may be required. So essentially, just in a nutshell, that's the role that is played by the executor. So you can appreciate from this context that this is a very vital role, and whoever is chosen to play this role needs to be somebody who will understand what needs to be done and will also have the requisite competence to see to it that everything that needs to be done in accordance with the Administration of Estates Act is dealt with. Now, the other question that we touched, the last one before we move on to other questions, we dealt with the question of how often should I change my will and where should it be kept? So we wanted to find out, now that I've concluded a will that complies with all the formalities required from a South African law point of view, I have this will. However, I feel that I want to make certain changes. How do I go about making those changes? Well, Asanda touched on that those formalities that are applicable to preparing and executing a will still need to be adhered to. And the changes, you can make them as and when there is a need for you to make a change. For example, you've gotten a new property that you want to include and determine how the property needs to be administered upon your death. You can then effect the change. And then with regards to where can my will be kept for safekeeping, well, you have other options and avenues that you can explore, such as if you have a safe wherever you may be residing at. If you have a safe within the household, you can choose to put it in a safe, lock the safe, and you know that it's there. And you can disclose to have whoever you want to disclose to, say that I have a will, it's in my safe, here's the code, or whatever. You can have some sort of arrangement. But this would be in an instance where you try to keep the will, to yourself, but obviously disclosing to other people. Another option would be where we've encouraged people to approach qualified lawyers next week. If you approach an attorney who is able to assist with offering the services that are of preparing a will, then you can ask that attorney to keep the will in safekeeping. So that will mean that the attorney will keep it where the attorney's premises are located. However, it's very important that once you've chosen to exercise this option, you need to communicate to people that you can trust. Say that I have a will which has been validly prepared. It's in safekeeping of attorney XYZ located at YB, and then this is the contact details. should anything happen to you, then it'll be easier for people to approach that attorney and say, you know, we've been told by the deceased that there's a will in your safekeeping. We would want to have a look at the will. So that's very important. And the last option would be with what's happening in this day and age where we have banks that are offering services of preparing wills and being appointed executors of various estates upon the death of the testator. So in that instance, the bank will be able to keep a copy of your will in its possession. However, it's very important also to note in the very same vein that in certain instances, there would be fees applicable to the bank holding and keeping in safe custody your will. So you also need to explore which avenue is best for you and how best to go about with that. So I think that's a recap of what we touched on the last time, just a high level so that we are all on the same page.
Okay, awesome. Thank you so much to both of you. I think actually if we have
I think there's another question which ties in, yes?
Oh, sorry. No, it's okay. The thing is, I want to, so the nice thing about being a facilitator and an MC is there's a program, right? And there's a script, but I can just wing it around, right? Because I'm busy talking to Mfundisi also on the side. So what we're going to do is just to, I'd like to ask people, those that ask questions, can you please be ready for me to call you out to be on video? So we believe that this really needs engagement, and it would be a bit tiring and exhausting for you to just watch us and not engage with us. So for those that ask questions, please be ready for me to call you out and to ask you to come onto the video. If not, at least have your mic on so that your name can pop up on the screen so that the two panelists can engage with you with your questions. So sorry, Asanda, Mfundi has just asked me to just touch on the 3 questions that you guys have to answer that they've asked now, just so that we're like in the same boat with everyone. So I'm going to ask Joy Malate. I'm not sure if she can have her video on, and then I'm gonna ask Ayanda Temba. I'm so sorry, I do not know everyone, so if I call you by name and surname without saying Baba or Mama, I don't know people's ages at this point, so I'll just call you by name and surname, and I hope that you'll understand. So can I have Joy? Joy, I know is my age group, so can you please come onto camera, and then can we have Ayanda Temba to also come onto camera? I didn't want to read their questions out, but if they take time, then they'll just join in as I read them, then you guys can answer them. Is that okay? Asanda, can you touch on the question that you were talking about that's tied onto something before I move on to this one?
Oh, okay. It's about who can be a beneficiary, right? I think it's a point that Unomfundo also touched on last time. Any person can be a beneficiary in a will, juristic person or natural person. Juristic person can be a company, that person has a legal standing, a company, CC, and what so forth, or a charity, or a natural person, us, right? And also an unborn baby. And another point I think is very important is whether or not if you are responsible for the death of your spouse, you can benefit from the will if you are named in the will. You cannot benefit if you cause the death of the deceased negligently or recklessly, intentionally, or in any other way. If you kill your spouse, you're not going to benefit from the will. So if the parties, if Dan and Nandi are married in community of property, Nandi kills Dan, she's not going to benefit. But is she going to benefit her portion of 50% portion of the assets? Yes, she will. Because you must remember they married in community of property, right? So she'll be entitled to a 50% share of the in community of property assets. However, that will be not because of succession. It will be because of the regime of their marriage. So she'll still get half of her portion, but she's not gonna get Dan's 50%.
Okay, I'm a bit afraid.
Maybe before you...
I'm sorry guys, I'm gonna have to cut you on this one. Can you please keep it, Thato, and we'll deal with it just now. I'm afraid that we're gonna run out of time before we actually get into today's session. So also those who want to ask questions, they can raise their hands. I think I noted I'm not sure if it's Mr. or Miss Mlambo. I noted your hand. So also, when I ask you to come, please do so. Joy is not here. I'll just read her question, then she'll just have to listen. So Joy's question, I think you did see it as it pops up there. It says, with regard to the signing of the will in the presence of the testator and the witness, how is this proven? Oh, she says, please come onto camera if you can. With regard to the signing of the will in the presence of the testator and the witness, how is this proven?
So okay, I'm not sure if I understand the question properly, but can I answer it, Thato?
Yeah.
It goes back to the presence. So if the testator must sign a will, the testator has to sign the will in the presence of both witnesses, and vice versa. If the testator signs a will and one of the witnesses is not there and signs the following day, that witness is not valid.
Oh, so it has to be done same time in each other's presence?
Same time, yes.
Wow. Okay. I'm hoping we've answered the Joy. She's typing there. She says she can't unmute her mic. So Joy, if it's not clear or if that's not what you intended to ask, can you please just clarify with us there? And then her next one was, if Dan has his own will, the executor will calculate the value of the joint estate and apportion 50% to Dan's beneficiaries. What happens when there is no liquid cash? Example, money is tied up in physical assets such as a house, etc., that is jointly owned, hypothetically speaking.
Yeah. So yeah, no, you can go, Asanda. I'll come up to you.
No, please deal with it.
So I was saying, when we deal with an estate, so we're literally referring to all the assets. Now, when you speak about assets, it doesn't matter whether they're current, non-current, whatever assets that they are, they all need to be registered on that estate. They form part of the estate, as well as the liabilities, regardless of the structure or the fashion or the manner in which they present themselves. So you need to take that into account, everything. And when you speak about the 50%, so if it happens that there's a joint house that's jointly held, then that can be disposed of and then sold, and then the 50% residue can then be taken into the estate. So it's all dependent on how you want to go about it. There's also an option of saying, let's just say Dan and Nandi, they jointly own the property, the house they stay in, and Dan dies. And then obviously, let's just say maybe Dan didn't give the 50% of the house to Nandi. Let's say he decided to give the 50% of his share to his mom, for example. And then what then can happen? So that means that his will only be in respect of the 50% value of the house upon it being sold. So Nandi can have an option of saying, Dan's mother, as my mother-in-law, I can make an offer to buy you out by a 50% so that I retain full ownership of the house. Or then we can decide to sell the house and then you take 50%, I take 50%. So it's all going to be dependent on how they choose to go about it with it. So there are options and various mechanisms we can explore. I don't know if Asanda wants to add further to that.
No, perfect.
I've been unmuted. Thanks guys for an amazing program. I don't know if you guys can hear me. So with my initial question around the signing, right, I was asking in terms of, I suppose I assumed that there is no other party present where it's just the witness and the testator, right? Unless this has to be signed in the presence of another party who can sort of witness the signing by both parties. So I was asking, if how is this then proven, assuming that it's just the witness and the testator, say, signing without any other person's presence? How is it proven in the court of law that in actual fact, because I can backdate as an example, I go back and I backdate the signing and I say I signed in Johannesburg, you say you signed in Johannesburg, and we attach the same date. So how is this proven in the court of law?
Okay, so it happens. Actually, I think that's a practical question. It happens a lot, and you find, for example, witness. That's why the Act specifies 2 witnesses, right? So if everybody is going to lie and say which one and the testator signed on the 24th of October, actually everybody signed on the 24th of October, whereas the third witness, the second witness, which is the third person, signed on the 25th of October. and it goes to the executor wherever it needs to be kept, and the dates are the same as if this document was signed on the same day, when it has to go to court, really, the court has to rely on, in good faith, on the people that drafted the will. That means the testator and the witnesses. If the executor was present at the time, or the drafter, who would be in all likelihood the attorney was present at the time, obviously the attorney has a duty towards the court of etiquette and good faith. That's part of the profession. But other than that, there is no other way you can prove it. You just have to rely on the parties, that this was done in the presence of both parties. Because you must remember, the purpose of having a witness in a will, it is to witness that indeed the testator who has signed in this will is the testator, and this is the will of the testator, nothing else. It's not about the content. It's about certifying that this is the will of the testator. So if the testator is happy to let witness 2 sign tomorrow, whereas he's going to write a date of today, unfortunately, there's nothing much that the court can do about.
Yeah. Yeah, the faith part. We're like, okay. Okay, Joy says it's covered. It's a pleasure, Joy. I'm not sure if Ayanda Temba's here. I did ask that they be ready one after that. But Ayanda Temba's question says, in your expertise, which option is best between joint will and separate wills? This is the case of a couple married in community of property. Which will or which option is best between joint and separate wills? Sorry, for the person. Oh, Ayanda's. Is that Ayanda?
Yeah.
Okay.
Yes, I'm here.
Hi, Ayanda. Hi. So
Hi.
just for clarity's sake.
You were cutting there. I didn't hear you properly, but let me just ask the question again. I just wanted to find out, in your expertise, which one works best, the joint will or the separate wills? This is in a case of a couple married in community of property. Which one do you think works best? Because a couple might not agree. I might want to do a separate one, and then my husband would probably want to do a joint. But the one that really works and that is maybe taken more seriously or into account, is the one less than the other? That's my question.
Okay, thanks, Ayana. Maybe I can come in there. That is legal advice, and what we would advise in this context is it would be best for you to approach a legal advisor in this regard, because you will need to approach a legal advisor, the two of you, and depending on how you want to distribute your assets in the will, then you will get advice, take into account what you want to do and what you want to achieve, which regime would be, which option will be best to be placed taken by the parties. So it's not like it's a one size fits all, and we don't want to give advice. So that's what we say from that point of view, because it will be best if the two parties together or separately approach legal advisors and they will seek advice in that respect. So I think that's how we want to respond to that. Unless if Asanda wants to say something.
Yeah, and I think we're going to touch briefly on that, not extensively though, when we're dealing with the limitations to freedom of testation, right? Because it's one of the topics that we deal with. What limits a spouse's freedom of testation in respect of the different marriage regimes, which we have, as Thato had explained earlier on, the community of property, out of community of property with an accrual system or without an accrual system. There are limitations that those regimes can really create when one prepares or rather executes a will. And I think this your question, maybe we might touch on it a bit when we're dealing with that session. So can you just hold on in addition to what Thato has said?
Okay, she actually said it's covered, but I'm sure more information might just bring more light and insights, right? Okay, so we're moving on to, I don't know if the two of you are okay, you want to say anything before we move into today's session?
Yeah, maybe I think with the questions, maybe it would be best if you just read them out for us, as opposed to having to ask the people posing questions to come forward and say
well,
that.
If they want to ask a question, they should raise their hand. So it's just something we're doing for engagements purposes.
Oh, okay, no, that's fine.
We'll see how it works later on. If it's a bit slow, then we'll just shift back to me reading them out. I think we're also doing that for maybe the elderly who are not so tech savvy, who can't really, type it all out, but we'll see how it works. But thank you so much, Thato, for that. I think we'll move on to that if there's no time. So just to mention to our audience and for those who came in a bit later, thank you very much for joining us. We're talking about wills and testaments, creating a lasting legacy. And we have Asanda Dipakube, yes, and Thato Mashishi as our panelists. Okay, so what we're going to be talking about now, what the panelists will be covering are getting your estate plan right, trusts, appointment and role of an executor in the administration of a deceased estate, wills drafting outside South Africa when assets are in South Africa, and in-estate succession. That's what it's called as an in-estate. Yes. Okay, so questions. Oh, yeah. Okay, we're in it now. We're in it. Okay. So I guess for me, because you two work well together, I won't mention, I won't say who's answering what. So I'm reading out a question and you two, in your intelligence, will just go with it, right? Okay.
So much credit. I'm flattered.
Of course. Okay, so our first question is, what is an estate plan? Understanding the difference between an estate plan and a will.
Okay. So what is an estate plan and the difference between a will and an estate plan? So an estate plan is basically creating a plan to deal with your assets and the distribution thereof in the event of you dying, right? So basically, it's a set of documents. I'll specify them that are crafted together. It's a process. It's followed upon your death, and it's the same intention as a will, right? Its purpose is to allow for the protection of your loved ones should something happen to you, so that there's no legal hassles and uncertainty as to what must happen to your children, your dependents, and your finances in the event of you passing away. So you basically carefully structuring your finances and assets in the way that ensures that duties are minimized, right? When I say duties, I'm referring to estate duties. If you go to your attorney, they will break this down in detail. What will this entail, right? So to make sure also that there's sufficient liquidity to meet the liabilities, because you must remember, if you have a will, the executor is first going to meet the liabilities. Thato mentioned it, that he's going to post and call for creditors and whatnot. At the end of it all, when everything is done, it is only then that the beneficiaries that are named in there are going to benefit from whatever assets are left over. It may happen that nothing will be left over. And it's so sad that today in South Africa, stats are showing that most of the wills, people leave wills, right? I think it's a good intention, but then at the time when the will, the executor has to administer and control the will and administer the estate, the assets, the liabilities exceed the assets. There is no money left for the defendants. Then the minors have to fend for themselves. If there is the house, the wife, if you are married, is a housewife, it becomes a very sticky situation. So you don't want to put yourself in that. You want to make sure that you have a proper estate plan that ensures that liquidity, your assets will be able to meet your liabilities. After your assets have met your liabilities, there will be sufficient assets left over to take care of your beneficiaries. And then the difference between the two, because many people misconceive the two ideas, right? It has the same purpose and intention in mind, but a will is just but a component of a comprehensive estate plan. So what would then be included in an estate plan? So you have your wills, you have your tax and estate duty planning. So your financial advisor or your attorney will advise you how to put these documents together. Because, so when we mention the tax and estate duty, there are directives in SARS directives that speak to estate duties, right? For example, if your net estate, you have a net estate, the net of your estate is more than 3.5 million, which is the threshold, then you will be charged 20%. Let me make an example, just bring it closer to home. So if your assets are 5 million rands, right? So you owe, your estate will owe the government 20% from the threshold, which is the estate will owe 20% of 1.5 million. It is only after that has been done, then your beneficiaries will receive, of course, subject to your estate paying the liabilities. So your plan really wants to make sure that that is taken care of. And also the appointment of the executor, the power of attorney. If something happens to you, you're not dead. You need to have a document that deals with how your finances must be controlled in the event that you are incapacitated. You can't talk, you are disabled by some other reason. So you can't control your finances. And you know, God forbid, that your spouse or your partner or whoever is closely related to you is not disciplined financially. You really want to have a person who will be able to pay the debts, pay the school fees of the children, take care of everything as was when you were okay and able to take care of your finances. So that's another document that can be included there. And how to appoint, it also has a document, and the attorneys will advise you, how do you appoint guardians for your minors? The aunt, my sister might not be the perfect guardian for my children. That is important because we tend to make emotional decisions. So if you approach professional people to help you with your estate plan, they will give you all the pointers that you need to look out for when you are appointing a guardian for your children. Because, yeah. And then what else? Advanced care directive. That is the same as a living will. So those are the documents. It's a compact, a comprehensive estate plan. It's a whole list of documents that speak to each other as to what must happen to your estate and your monies in the event of your passing.
Yeah,
I think.
I think you touched on an important point there, that, you know, it's very important that you get advisors to help you with, you know, planning for your estate. I mean, because you need other people with the expertise to help, which would be people that are doing with your tax affairs, people that will give you a legal point of view. So it's a consortium basically of advisors to see that, you know, all the T's have been crossed and all the I's have been dotted. So it's very important. And the other point that you made mention of is it's very important that, you know, there is some sort of residue at the, you know, the after paying off your liabilities, because if there isn't any residue, there's nothing left, then there's nothing left, because there's also
There's no point.
There's other costs that need to be taken care of. Whoever you're appointing as the executor, that person is always entitled to a fee. So and the other fees, setting up trusts and whatever administrative work that needs to be done. So it's very important, because you might think, I have the car, Danny is living a car, I want this car to go to my son. But if this car is financed, then the bank will be the creditor and they might lay a claim and say, because, I mean, this car. That's why it's so important that, you know, we have other covers such as life insurance and insurance. So should they, you know, the unfortunate happen, then you know that you have sufficient liquidity to see to that you can distribute some residue of the entire estate.
And look, Thato, it really makes the exercise futile if you have a house, for example, of 5 million rands and a life cover of, let's say, 6 million rands. You still have other liabilities. You've drafted a will, but your house is still owing. The cars are still owing. There are so many debts. So your life cover is as good as non-existent. So that's really what an estate plan is for. It's to make sure that if I have 5 life covers, they're going to cover my liabilities. I have so many assets, everything will be paid off. And whatever remains is the residue thereafter. It will take care of my children until they are self-sustaining or until death. if you have a child that will not be able to work for himself or herself.
Yeah.
Okay.
Maybe just to, in conclusion on this part, just to add another element, also with the life cover situation. So usually these days, it's part of the requirements before you finance, get a home loan, the bank would want you to take out a loan and seed it to the bank. What that simply means is, upon your death, that life cover will go to the what's of the house. Not necessarily it will go to somebody else. So you basically have your rights to benefit. You take that right to give it to the bank. So the bank will be the one that will be entitled to any proceeds of that life cover. But you know, we're not trying to be detailed, but we're just trying to give some high level context into these discussions. That's why it's very important to get experts to come and advise when you do estate planning, to see to that, you know, we take into account what are your liabilities, what are your assets, and try to get to a point where at all times you have asset exceeding your liabilities, so you can have some form of residue at the end of that exercise upon your death.
Okay, great. I must say, I think I should just try and open a, what is it called now? A session. What do you call these things? Where we're in a hall and we must just have you guys, yes, and everyone must just come, obviously under COVID regulations and policies, and just have you there, and we're just there for 5 hours. Because I think also we can just go on to session number 3 in 2 weeks' time, right? Thank you so much for that, though. You're very clear. And thank you to the people that are commenting, where we see your comments. So the next question is actually 3 questions in one, but they just tie up together. It says, what happens if you have assets in South Africa, but your will is drafted in another country? What are the implications of that, and which law would then apply?
Okay.
Yeah.
And can I take that, Thato?
Yes, you can.
I don't mean to shine, eh?
You can shine all you want.
Okay. Well, okay. So in terms of, there's also a legislation governing wills, right? Specifically wills. There's a legislation governing administration of estates. There's a legislation governing people, situations where people die without leaving a will, right? So as part of that pact, we have the Wills Act. It deals with that situation, right? So it really says that if you die, or if you prepare a will, let's say in New York, right? And then the internal laws, and you have assets in South Africa. Let's assume that you're a South African citizen, right? Hypothetically. Then the internal laws of New York will apply. Your will must comply with their laws, right? And then if you prepare a will, or you must be a resident there, or permanent resident, it doesn't matter what residence you have. You must be a resident or whatever, then the laws will apply. If you prepare your will on board of a vessel or airline or wherever, then the laws of the state where that vessel or aircraft is registered will apply, or whichever is the closest relationship or closest state to the vessel, then those laws will apply. However, there's an important qualifier in respect of people who are South African citizens, right? If you're a South African citizen, it doesn't matter where you are in the world, your will must be in writing. So if the laws of the state in New York say that you can have a video recorded will or an oral will, if you're a South African citizen in South Africa, that will is going to be invalid. If you have assets in South Africa, it's going to be invalid, because you must remember your assets are going to be distributed according to the laws of that state. So if your assets are in South Africa and your will does not comply with the requirements of South Africa, then it becomes invalid. So it must comply with the internal laws of that state and also be in writing, which is one of the requirements of the South African law.
Okay, Thato, I feel like you guys into each other's information, so I think you have something to say.
I think Asanda did a brilliant job explaining this to us. So yeah, I don't want to add anything to that. I think she covered all the ground.
Okay.
Yeah, because you must remember the Wills Act, that pact that I spoke about, dealing with the administration of estate wills and so forth, that is to protect your assets. So as a South African citizen, that act is to protect you and your interests. If you don't comply with it, it doesn't matter where you are, then you cannot be protected. You left exposed, yeah.
Okay.
Maybe just to add just one thing, short thing. I think already the viewers can appreciate that we're dealing with a lot of laws. So I mean, one I mentioned the Wills Act. There's also the Interstate Succession Act. There's also the Trust Property Control Act. So you have all these legislation. So that's why we emphasize that when you prepare your will and you prepare your estate planning, go to specialists who have the expertise to assist. Because I mean, we don't want a situation where you just go on Google, you download a template, you fill it, you don't know where the template comes from. So to avoid that, it's best that you approach competent advisors in this regard.
Yep. Okay. Okay. I think we need to remind them actually after every 5 questions or 3 questions that yes, this is good advice, but it would be better to go to, you know, professionals or rather people that can actually help them through this. Okay, so I'm not sure if I should move to interstate succession or I should move to executor and administrator. What do you guys think?
Thato?
Okay. we can go to administrator and executor.
Administrator and executor. Okay.
Yeah, so
yes?
Okay, no, it's fine.
No, you wanted to say something?
Yeah, I just want to give just an overview.
And a background, sure.
Of that, yeah. Because I mean, previously we had, when we look at the Administration of Estates Act, previously it made reference to administrator alongside executor. But what happened now is we no longer have reference, there's no reference whatsoever to administrator. So we only have reference to executor. And previously, like an overlapping role which is played. But now we have executors who, like I said, they perform that role of being guardians and they're the custodians basically of the entire estate. And I've given the duties before, so I don't want us to get into that. Probably we can move on to something else in the interest of time.
And before I ask the question, just in case there's anyone who's like me here, what is an estate?
Okay.
Yeah, so I'm just going to try to put it in layman's term. So when refer to an estate, it's the basically the quantification of all the total assets and liabilities which belong to a particular individual. So basically that's what it is. We're referring to all the assets, all the liabilities, and those would make up a person's estate. And then we can do that exercise any of the day. So I'm just giving, and so that the viewers at home can understand it in a not so technical way. Yeah.
Yeah. And for anyone else who might listen who's never done accounting or economics, what are my assets and liabilities? Just before we get into the real questions.
Yeah, so basically when you refer to your asset, it could be a house that you own, could be a car that you drive, it could be a piece of land that you own, it could be...
Yeah, you can speak. No, I just wanted to highlight something in what you were saying. Own is very important. It's not relative, people, not relative. It's important. A bond is not an asset.
Yes.
If it's not paid up, it's a liability.
Yeah, that's very important. So yeah, we're saying all the assets that you own registered in your name and you know full ownership and control and possession in certain instances. So when we speak about liabilities, so basically this would be your expenses and your credits, whoever you owe, every other loan with the bank, you know, you've taken a loan, it's COVID time, you took 200K from the bank.
Yes, Mfundisi Makapela says bond sikoloto.
It's a debt.
So you've taken a loan from the bank because COVID times, that becomes a liability, and you owe other people. Then those are generally liabilities. So there's a distinction, and I don't want to get into the technical.
Get into the different types of liabilities.
Current,
current. Okay, I think overall, generally, now we can move forward as we're going to do the executor and administrator, just to understand, in case you're here talking to me about assets liabilities, I'm thinking, yo, what is he talking about, right? Okay, so
no,
thank you.
I think we can move on from that question. You can go to other questions because, yeah, I just touched it just at a high level.
Oh, was it a highlight? Okay,
yeah.
Okay, so we can just go back to interstate succession. Ne? Okay, so what happens if the deceased dies without a spouse or children? What happens to the deceased estate? So make me as an example. No husband, no children. What happens? What happens to my estate?
Okay. No husband, no children. Then Manini's estate is gonna go to the parents. You must remember, interstate succession refers to a person dying without leaving a will, right?
Yeah.
So the general order is you single, you don't have a partner, there's no document that is regulating what will happen to your assets. Therefore, your parents, if they are still alive, they're going to inherit all your assets, right? If your parents are not alive or you are survived by umama and the dad is not there, then mama is gonna get 50% of the share, right? And the descendants of daddy will get the other 50%.
Really?
So your sisters, for example, yes, your sisters. So but then if they are both surviving, 50-50, if one parent is not there, the descendants of that parent will benefit, right? Okay. If there's no descendants, direct descendants, whoever is closely related, blood relations, close blood relations. So there's degrees, it goes further down.
So must this be stipulated in any documents in written form, or that's just what the law says?
That's what the law says. The laws that we're referring to earlier on, Thato, there's degrees, it's stated there. If mommy and daddy are not there, it's in that order. There's a certain order that it would go.
Okay, that's really deep. Okay, then. So when we move on, then we say, does an illegitimate child have a legal right to inherit from his or her father? And before anyone answers that, I want you to tell me what illegitimate means. But doesn't it, not because I don't know, just for background's sake, does an illegitimate child have a legal right to inherit from his or her father?
Okay. An illegitimate child is a child that is born outside a marriage or a union. Mm-hmm. So, for example, in the case of Nandi and Dan, you remember in that case study, Nandi and Dan have 3 children, but then there's also a child that Dan has outside. That child was not born of their marriage, right? So that child has every right to the estate of the father. Whether the child is mentioned in the will or not, if that child is dependent on Dan, then that child is entitled to benefit from the estate. And then it can be contested as long as the child is dependent on the father. As long as the child is minor or dependent, that child has the right to the father's estate.
Yeah. Before Thato says something, I can see that he wants to say something. Now I know his movements. I don't know if I could be right. Traditionally or culturally, then, if this boy is a boy, and he's a firstborn, does this have to do with anything in the will? Does it change anything? Does it give him a better right to No,
it doesn't give him better.
Okay.
No.
Okay. Awesome. Thato?
Yeah, I just wanted to add to that point that, what we spoke about there, we are dealing with interstate succession, but also coupled with that, there's the Maintenance Act, which also comes into play. So there we're referring to an instance where a minor, or even, it doesn't even have to be a minor, for as long as a child is dependent, on the parent for survival, then there's a duty for maintenance to be paid. You could be over 21, but if you're still, for example, attending university, there's still that obligation that rests with your parents to take care of you. So it's all a matter of understanding, is there a need?
Yeah.
Okay.
And once
Our movie Frozen has begun. Okay. Sorry, Thato. Can you give us the last 10 to 20 seconds of what you were saying?
Yeah, so I was saying you can have an instance where we're dealing with a child who may be, let's just say, for example, 21 years of age, but this child still goes to university and remains dependent on the parents. That obligation still exists for the parents to meet the child. So, but then, like I'm saying, it's another piece of legislation that we're dealing with. So, with a lot of laws, that's why it's very important. Yeah, this is the Maintenance Act. It's very important that you get people that know these type of legislation to give you requisite advice in that regard.
Okay, and still, as Thato's mentioning, still under maintenance and those legislations. The next question says, can an adopted child inherit from his adoptive parents and their blood relatives and also from his biological parents? Can biological parents in turn inherit from the child? So an adopted child inherits from both his adoptive parents and his blood relatives and from his biological parents, and can then the biological parents in turn inherit from the child when the adoptive parents have died?
Okay, I think I saw one of the participants also posing a question like that.
Adopted children also benefit. Yeah, that's from Tshepo Aphane. I hope you'll be answered. Yeah.
So an adopted child can inherit from the adoptive parents and their relatives, right? Okay. However, if that happens, remember there's no will now. If that happens, that adopted child cannot inherit from the biological parents. So it cannot be double. Where there's no will, it's not double. The child will inherit from the adoptive parents, but not from the biological parents, unless one of the biological parents is the adoptive parent. Then it's a different situation, right? Okay. And then in an instance, if there's a will, then of course the child would be specified in the will. If there's a will and the child is specified in the biological parent's will, then the child will also benefit from the biological parents. So when there's a will, it's a different story. And then whether the biological parents can inherit from the child in the instance where the parents, the child cannot benefit from the biological parents. Yes, but this can only happen if the child has specified in the will. So biological parents will not benefit from the adopted, the child that has been given out for adoption, if that child did not specify in his or her will that I want my biological parents to benefit from my assets.
Okay. Thato? You're good. All right. Thank you so much, Asanda. I hope Tshepo is answered. And then the last question under interstate succession. What happens when a husband dies interstate and leaves behind a civil marriage wife and a customary wife? Can both wives benefit from the estate of the deceased? Asanda, can you please, for the benefit of everyone who might not know, can you tell us first the difference, what is a civil marriage and what is a customary marriage, or customary wife and civil wife? And then you answer the question.
Okay. A civil marriage is a marriage that has been entered into between two people, right? It must be one partner. In terms, again, there's a legislation coming in, Marriages Act, right? One partner. I don't want to get into, I'm trying to be diplomatic, Bazalwan. I don't want to get into details of it, right? It's one partner. So, and then a customary marriage. So that will be a civil partner. Yeah, or civil wife or civil wife. And then a customary marriage. A customary marriage is a marriage that has been entered into in terms of the traditions and practices of the indigenous people that you are part of, where you come from. Umtshato wesintu. Next. And there's an act as well regulating that. Right? I'm not going to get into the formalities of both marriages, We're not talking about marriages today. I'm not going to get into the formalities. But importantly, right? Importantly, you cannot. So let's say, for example, okay, in a civil marriage, you can't have more than one. Example of Nandi. Yes, example of Nandi is a civil marriage.
Yes.
It's a civil marriage. You cannot, it's a monogamous marriage. You can't have more than one partner. It's one partner, one partner. In a customary marriage, you can have as many as you want.
Yeah.
There is no limitation. So going back to the question now, we have a civil marriage partner or wife, and then we have a customary partner, wife, right? Or partner. In that situation, you cannot have those two marriages coexisting. It's illegal. The first marriage that was entered into will be the valid one, and that is the partner or wife that will benefit. So if the husband or the wife, whichever, guys, I'm sorry about the gender, I didn't want to specify, but I'm forced to. If the partner entered into a customary marriage first, there are requirements in terms of the law that a customary marriage must now be registered. But if it is not registered, it does not make that marriage invalid, right?
Okay.
And then the partner, Thato, comes again tomorrow and enters into a marriage, civil marriage. That civil marriage, remember, the customary marriage is not registered. Nobody knows about this marriage except for the family and whatnot, and he becomes naughty and enters into a civil marriage with a city girl, right?
Yeah.
A marriage with a city girl or the city whoever is not going to be valid because there is already a marriage that is in his existence. The implication of that, then should Thato die, is the city partner is not going to benefit from the estate. That's as painful as I can put it.
Yeah. Yes, Thato. Wow.
Asanda, I think you are touching on a very important point.
Yeah.
And I think I just need to emphasize it more, particularly because when we deal with customary marriages, a lot of people tend to, they have a lot of ideas around, you know, it needs to be, you know, registered. And if it's not registered, then it's seen as not being in place. I think we've seen the recent case around WHP and how that happened, where the court has said, you know, that it's not even a requirement for the bride to be taken to the groom's family to be welcomed, as long as they have entered into that marriage in terms of customary marriages and customary laws, then it becomes a valid marriage. And then what people need to understand is with customary marriages, by default, as with civil marriages, they're in community of property. So in that the other spouse would be entitled to 50%. And that's why we always advise people that before you go and even start the process of paying bohadi, lobola, it's very important, if you don't want it to be in community of property, that you seek legal advice, because once you've started celebrations and everything, you might find yourself on the back foot. That's why it's also important. But I'm just, you know, it's a detour, but I'm just emphasizing it because we're here already. So it's also important around marriages. Yeah, like Asanda was saying, there are other legislation, other laws applicable to this, the Marriage Act, and there's the Recognition of Customary Marriages Act. So a lot of laws are at play, but it's very important that you approach advisors in this instance to advise further.
Yeah, I think, well, for a layman like me, you know, I think it's important for us to look at the coin on both sides whenever we make decisions for our lives, whether the decision is for myself, for my parents, for my children, in a job, anything that has to do with my life, my finances, and I should think of what happens after I die. Because I think in the example of Tshepo, most of us live for the now. So whatever I do for the now. I lay by for my kids, it's for the now. Oh, everything that I do for school, I never think 5 years from now. I don't even know what's going to happen to me tomorrow. I might drive, God forbid, and be in a car accident. Then what happens then? I left no life cover, no policy, no funeral cover. And unfortunately, when you live a life and you die, you forget that there are people that will be that will be affected when you've left, you know, whether you leave something for them or not. So I really like this, and the fact that you guys keep including or footnoting the fact that there are so many laws for one scenario. We can't look at just one, you know, there's customary law and there's the other law for just one scenario. So thank you so much for that. And you guys are doing great. Thank you very much. Okay, so we're gonna move on. Okay.
You are far too kind.
I have to be. Okay, so we're gonna move on to just 2 questions before we move on to trust. We're actually moving well on time, maybe not, but let's do the last 2 before we get onto trust, and then we do our question and answers. I just checked the time now. I think we should do 10 minutes and then have 15 minutes to close off with question and answers. So the next question will be then, can a wife or husband contest the will of the other? Under what circumstances can this be done? Whoever's going to answer this question, can you please start with the term contest? I'm sorry if this is taking long, but I'm just trying for us to understand the questions for those who are listening. So please tell us, define contest, and then can a wife or husband contest the will of the other? Under what circumstances can this be done? I'm sure it makes sense, but just to clarify things.
Yeah, so I think when we deal with contestation, we are referring to it being challenged. You know, it could be challenged in a competent court where somebody feels that, you know, this is not valid, I want to disapprove it, I want to set it aside, whatever grounds the person might have. And it could even happen that you could have an executor has been appointed. You know, certain times there are rules that may suffice from nowhere. Now suddenly this person has 20 roles and the position of a role that's different to the others. So that could also lead to a challenge of those other roles which are there. And then you want to reach a situation where you want a will that can be declared the one that's valid out of all those other wills. So you could then approach a competent court and to challenge that. And then the other things that, you know, may be challenged from a will, for example, you've excluded somebody from a will, the other legislation which we refer to, such as the Maintenance Act, when the person can lay a claim following the Maintenance Act, saying that even though your wishes are that you didn't want me to inherit anything as your spouse, then I can have a leg to stand on should the spouse be surviving the deceased. So it's all dependent on, you know, a lot of grounds. So, but I don't want to get into the minute details, but there are various ways which a person can follow to lay a challenge against the will. So that's why we emphasize that, you know, it's very advisable that when you conclude and during the period of concluding a will, you approach a competent legal advisor who's going to give you the advice as to how to go about to make sure that your will complies with all the formalities. So, yeah.
Okay. Did you touch on the circumstances under which this can be done? You did. Yes. Okay. Sorry, I'm just managing this whole thing and the questions. So if I get lost in the moment, just please forgive me. So then the last one under this in interstate succession would be, how does a marital regime affect the ability to bequeath your estate? What are the limitations on freedom of gestation due to a marital and life relationship regime? Yeah,
I think we touched on this earlier on where we dealt with either in or out of committed property. So it's just going to be a repetition. Yeah. I think we have that on the point.
No, that's good. And then we're done with executor administrator, the differences. You feel that people understand what that is? And we move along to trusts.
Just 2 things. I'm so sorry. Just 2 things.
No problem. No problem.
On the limitation that Thato just referred to now, he spoke about contestation, right? Freedom. Everyone has a right, or rather the freedom to put whomever they want in the will. If you want to exclude your child, it's up to you, but that will be dealt with later, right? You can exclude, you have a freedom of testation. The limitations that he's referring to now, he dealt with the marriage, right? The one of the limitations, for example, this question was asked earlier on, in community of property, right? The challenge with the nature of the regime itself is that it means that you cannot bequeath what belongs to the other partner without that partner's permission. Going back the joint wills that Thato was talking about. If you are married out of community of property with an accrual system, right? And let's say it's Nandi and Dan. Dan's accrual is higher than Nandi's accrual. And Nandi dies first. That means that Nandi's estate has a claim against Dan's estate for the difference of their accrual. So that's really quite a limitation, because Dan might not want to leave that difference to Nandi, you know?
True.
But then there's a claim against Dan for the difference in the accrual. And another thing is cohabitation. You must, cohabitation, unless partners have a formal arrangement, a contract or whatever it may be, there is no law that will protect the partners for claims against whether you bought the sofa together. If there's nothing in writing, you're not going to benefit. So that's also quite a limitation, because look, you might want your partner to benefit and get that sofa. And you guys bought it together, but you won't benefit because there's nothing in writing, right? And also pension fund, very important. The pension fund. Okay.
No, you can continue.
Oh, okay. Yeah. So the pension fund. In the pension fund, you might have a beneficiary. In most instances, you'll have a beneficiary that you have elected there, right, in the pension fund. But the trustees of the pension fund, whichever pension fund you belong to, in terms of another legislation, Pension Funds Act, they have the right to deal with the pension fund as they see fit. So if you have written one child as a beneficiary of the pension fund and you have 5 other children, you did not write them and they are dependent on you, and the only asset there is the pension fund, the trustees are going to make sure that they benefit from the pension fund, because that's what the Act says. Yeah. And the maintenance that Thato was referring to, and also the Constitution.
Yeah.
So if you write something in your will that is contrary to the Constitution, of course, that will also be a limitation, because your wishes will not be carried out.
Okay, before Thato speaks, thank you, Asanda. We have 20 minutes left, literally. So Thato, can you please talk maybe in a minute or two? And then we have these 4 questions about trust that we need to cover. I'm not sure if we're going to do all of them, because we've got 9 questions from the participation.
I think maybe what we can do, I will be as brief as we can, and then on the trust, I can just give an overview.
An overview, yeah.
And I think that will save us a lot of time.
A lot of time, yeah.
It's also important what Asanda raised. So in other countries, there's what we refer to as common law marriage, where it's deemed that people are married by virtue of having been together for X amount of years. It's not the case in South Africa. We don't have such a thing. So if you're not married, you're not married. You cannot enjoy the benefits of marriage when you're not married. However, there have been other cases. Yeah, just so that people know, by virtue of you having stayed together as husband and wife, that doesn't mean you are husband and wife unless you are married. So that's something that I just wanted to put out there. And then, yeah, I think now we can move on to trust. And here, what you want to establish. So basically, we have different trusts that can be concluded or set up. So we have what you call testamentary trust. So basically, this would be a trust that is set up based on the contents of a will that we discussed. So this would be, it would give itself its mandate from the will, and that would dictate how it's set up, who are the trustees, who's appointed, what it seeks to do, and how it will be managed and structured. So that's number 1. And the second one is what we call an inter vivos trust. So basically this one, we can refer to it as a living trust. So the distinction is, with the testamentary trust, think of it this way: you are dead as a testator. You set up a trust to say, this is how I want this trust to run, and these are the people I want to be trustees, and however beneficiaries, you set the modalities, but you're not there to witness it coming into fruition. And then the second one, with the inter vivos trust, you are present, you are still alive. So this is where you probably might want to, and this is also a factor that's considered when you do estate planning. So where you want, for example, you could say your immovable assets that could be your house, your land, and whatever, you can put ownership, rest ownership in a trust so that you can afford those assets some sort of security. So that's also dependent on how you want to structure the trust. However, there's what we call another piece of legislation. It's called the Trust Property Control Act, which governs how trusts should be set up, who should be appointed, how they should be structured. And because when you go to the master's office, either in Joburg or Pretoria or wherever you may be staying, you will need to look at there and you need to comply with the formalities, the trust deed. There's certain requirements that need to be in a trust deed that, you know, before you lodge it, it will need to be checked to see if it complies with the law. So basically you have trusts that are set up. One, you could set up a trust in an instance where you put it in your will as part of testamentary trust, that in the event that you die and then you have minor children, you can then decide how those will be. You could transfer assets into that trust so that they could be beneficiaries, and then you could decide how the modalities will be structured. So basically it's just to provide some sort of structure that is formalized and you know will be adhered to, because the contents of the trust will need to be, I mean, at all times be carried out, and you literally specify what the purpose of the trust is and how it is meant to be run. And yeah, but also with trust, it's very key that you understand the tax implications. That's why you need to go to, because once you want to dispose of property in a trust, there are taxes which you will need to pay, and those tend to be heavy as compared to if it's just natural persons disposing of property. So those are some of the considerations that once you've approached an expert in this regard, they'll be able to advise further.
Guys, can a person have a trust and a will at the same time?
Short answer, yes.
Okay. I love that. Okay, Asanda.
Look, this trust, I think that they're very important vehicles. You know, I'm just going to refer to the living trust that one of the trusts that Thato referred to. You can take care of your business, for example. If you're a business owner, you're self-employed, that business can be in a trust, and it can provide for your children and your children's children and the children of your children up until the 10th generation, if you want to. You can pay for the private school. Your grandkids and your great-great-grandkids can be taken care of by the trust. So it's not as narrow and as confined as a will, you know. It goes a bit further. Yeah.
Okay. So we've got something like four minutes or so, and then we get into questions. We're actually going to extend it to like 20 to 25 minutes for the question and answer session. But just for like extra information, how important is it for me to know of the laws or this specific law when I want to draft a will? So do I go to attorneys like this week, right? This is the week of the wills. Do I just go with no information whatsoever and just want to drop a will? Or is there specific books or specific websites that I can go to and actually have more information on the drafting of a will and trust? And because let's say I just want to change my life and I want to make sure that everything of mine is set up for even after I die. Is there specific information I can gain from anywhere?
I think on that end, it would be very advisable to approach a legal advisor in that regard. You don't want a situation where now you're reading things from the internet that may be misleading, and you have thoughts around which are not present and not applicable. So it's best that you go and have the consultation with the legal advisor, and then you'll be taken through the process. So they will explain everything to you. You don't need to have any background information. I mean, there isn't any assumed learning that you should have or any experience. So it's just a consultation. They'll take you through the entire process.
And the legal advisor being?
Your attorney, for example. Like this week, everybody can approach an attorney for free, you know. And I really think everyone should use that opportunity, because as much as we have so many professionals in South Africa, it is shocking how many people don't have comprehensive estate plans. And for you to try, if you are not a legal person for you to try and piece all of these legislations together. It's going to be a pain. So rather go to the person who has expertise of what you want. That person can give you your options. You can ask for options, which options would be best in your situation. And you must remember, now it's going to be a personalized situation. So you can narrow it down. Options are available, you will be given the options. You don't have to deal with the legalities. Because now if you're trying to find the information on your own, you're gonna meet legalities, different statutes and legislations, and you're not going to be able to understand which one goes with which one, because none of them go in isolation. They don't work in solos, right? They inform the other. So you won't understand which one informs the other if you're not a legal person.
Okay. All right. No, thank you so much. It was very informative, and we have comments here on the participation that say it was very informative. Now people know what steps to take henceforth. So we're just going to get into the questions, right, that we have here, and I'm going to ask the participants to unmute themselves because I also wrote their names down. So we're going to start with Nigiwe Tamisi. I don't know if Nigiwe, if you're still here, you can hear us. Can you please unmute your mic? And Nigiwe's question is, we Christians should have a portion of our estate. Oh, yes, as Christians. Oh, there she is. Please ask your question. Thank you so much for joining. Is she still there? Oh,
yeah.
video.
Hi.
Hi. Hi, guys.
Yeah. Hi, how are you?
Good, thanks.
You said the thing, the equipment is under Nikiwe's name.
Yeah, but it's his question. It's my dad's question.
Yeah, we just wanted to know as Christians, Manini, if there's any portion that we have to bestow to the church, in terms of wills. And if there is, could the lawyers there advise us as professionals what channels we should follow and what it is that we have to do?
Sure, Thato.
Okay, yeah. So I think that speaks to the freedom of gestation. So you can give and assign anyone to be a beneficiary. For example, you may decide that in your will, you want Meals on Wheels, for example, to be a beneficiary. And you can specify how much money or assets or whatever you want Meals on Wheels to benefit, or if it's the conference itself. So there are, that's why it's a structured document. You decide what you want to assign to whoever. So I think that's something very important to say. Yeah.
Okay. All right. I hope are you answered, Nigiwe and Baba?
I think
yes. You can give us a thumbs up or just type yes, and if not, we'll just go back to it. Okay, I just received also a message. Some people would like to be anonymous. So what I'm going to do then, without mentioning any names, I'm going to read the question. Then the person that typed out the question, if they want to be known, they can just come up, have their video on and unmute themselves and then engage with us. I think it's a lovely platform. But should you want to remain anonymous, then I won't mention your name. Thank you for bringing that up. I actually never thought about it. So we'll just carry on. And then the next question would be, what happens when the estate is concluded, however, the other spouse does not have enough funds to pay the lawyer? What happens when the estate is concluded, however, the other spouse does not have enough funds to pay the lawyer? And for whoever asked this question, if it does not seem clear enough, can you please come on if you can and just clarify? But I think you guys can hear it. Do you understand it?
I think so. I'm going to attempt, and then Thato is going to help me if I didn't really do justice to the question. Okay. So if an estate is concluded, I'm assuming a will, right?
Yeah.
Because oh no, not a will. An estate is concluded, and then they have money to pay the attorney. So we need to make a differentiation between dying without a will and having a will, right? So if you die without a will, you don't need a lawyer, right? The administrator is there to administer an estate of the person who dies without a will. So the administrator is going to do all the administrative work, which would ordinarily be done by an executor if there was a will. Now, in an instant, Thato touched on this one. In an instance where there is a will, the executor that has been appointed there could be a lawyer. So you're not going to need a third lawyer outside that. You've got the executor there to deal with the administration of the estate. And the fees, which is something that Thato really dealt with in the first session and last time session on the 3rd of October and beginning of the session, is that the fees are determined from time to time, right? There's a prescribed rate, 15%, 10% of the estate, but that is not going to come out from the surviving spouse. It's going to be paid from the estate itself. So all the work that the executor is doing, if the executor is an attorney, he or she is going to be paid by the assets or the estate that have been left behind. So the surviving spouse does not have to worry about those legal fees.
Okay. Thato?
Yeah, I think Asanda did an awesome job explaining. So it's very important.
I feel that you're being kind to Asanda.
He's very kind. He's very kind.
So what happens is in certain instances in a will, the testator can fix the amount, saying this, I want to cap the executor fee at X amount. And in certain things, if there isn't that the will, then it would be obviously what would be the applicable tariff at that point in time. So those, as Asanda said, they vary, but there are fees involved. Yeah, in the instance where there's a will. So yeah.
So because there are fees involved, I would ask people to please make use of this week so that you don't get to pay any monies to fix anything in your wills and your estates, right? Okay, so the next question, I'm not sure the person that has their mic on now. Okay, can you please raise your hand before you have your mic on? I'm back. Awesome.
Yeah.
The next question is, in the example you have of Nandi and Dan and the illegitimate child, what happens if Dan intentionally writes a will that excludes the illegitimate child? Will the will hold, especially provided the child is a minor?
Thato?
So you're saying Dan excluded the illegitimate.
Yeah, so Dan knows he's got the child and then he excludes the child from the will. So will the will hold, especially provided that the child is a minor?
Yeah, that's also speaks about, but you remember the intricacies involved. So there's that first leg is the freedom of testation, where you are allowed to give whoever you want to give, and you're allowed to deprive whoever of whatever you want to deprive them of. And there's that another leg where we have these things that do not change by virtue of operation of the law, which would be main and those other things. So it's not just a simple thing to approach. So in as much as you may want to exclude a person, there may be other grounds in which they may be entitled to benefit from that. But you are entitled as a testator to exclude people. If you feel like you don't want to give Manini anything from your will, then you specify, I don't want Manini, even though Manini may be my child. But Manini may have other grounds to stand on later on, other channels.
So now, I hope I'm not going, I'm not off-routing, but I'm not detouring. So if Akiriki give Dan and Nandi, right? And Dan has passed away, did Nandi have, or the illegitimate child's mother, did they have the right to contest if they know of the will and that their child is not included in the will?
Remember in this instance, they could have, legs to stand on and say, want to claim maintenance for the child or whatever. And here we've assumed that the will for all intents and purposes is valid. So we haven't, that's the assumption that everything has been concluded, but there may be other grounds which a person could stand on to challenge the contents of that.
Yeah.
But and speak to the validity of the will itself.
And if the tables were turned and Dan wanted the minor to be in the will, but Nandi didn't, then what would happen then?
So that'll also, maybe Asanda, you can go.
No, it's fine. It's fine. Go for it. And then I'm going to just add a bit.
So I was saying that's going to be dependent. Remember, if it's a separate will, remember there's also an option of having a joint will. So we are assuming it's a separate will. Dan has his own will. Nandi has or doesn't have a separate will. So we're just going to assume that. So whatever Dan has specified in his will, those wishes have to be honored to the T. So that's very important. If Dan doesn't want to include anybody, wants to exclude everybody, that needs to be respected. If Dan in his will says, whatever residue of my estate remains, I want to donate it to the TOC conference, that has to be respected. But there may be other legs for other people to stand on and challenge that. So as we raised previously.
Yeah.
Okay. Asanda, you good too?
So no, I just wanted to go back to the issue of the legitimate child, because it happens a lot. You know, it's a reality in our societies. There's always children that are born out of wedlock, right? That child cannot be excluded. Even though Dan did not include the child in the will, the mother of the child, as soon as you hear that the father of your child has passed on, make the effort of going out of your way to inform whoever is there, whether it is the master of the high court. Actually, it's actually the best way to go about it. If you don't want to have interactions with the wife or the family, to go to the master of the high court and inform the master that I think there is a will, and this guy or whoever, the mother has a child, therefore, can you please assist me, right? Then you will get the assistance. Because if the child is not included in the will, the child is a minor or is not self-dependent yet, then you can, like Thato explained earlier on, that will can be contested to provide for the maintenance of that child.
All right. We're good with both of you. I'm answered. Actually, that was my question. So, but in case anyone else was thinking the same thing. Okay, so I think we have, how many? Oh, we have the last question. Then we'll see if participants have any more questions. And it says, are you obliged to include your provident fund on your will if you have nominated beneficiaries with respective fund? I'm not sure if, yeah.
You're not obliged to. You don't actually. Your provident fund, your pension funds. Those are the things that you really don't want to include in your will. There's no point because you've already appointed your beneficiaries there, right? And like I said earlier on, if there are anomalies and there's issues that the trustees are not happy with, those are the trustees that are administering that particular provident fund or pension fund, then they will deal with it. And in most instances, it's where there are minor children that are dependent on you that you did not include in the pension fund, then that will be dealt with in terms of their law, right? In terms of the law in South Africa. But you don't have to include it. There's no point.
Okay. Okay. Yeah. Okay, then because questions are coming up now, the next one is, when the bank is your executor, is it a good idea for the bank to handle your estate?
I think that's something you have to take up with the financial advisor, as well as they will need to assess.
I think
what we need to appreciate is that, as we mentioned previously, some of the conditions we find that before a bank could be able to draft and keep your will in safekeeping, they would say that we can prepare your will on the condition that we are appointed executor of the estate. So that means that the bank will get a fee out of administrative estate if there's a residue. So it's a method you want to take with your financial advisor as well as your legal advisor and see to it. It's something that you'll be prepared to do, because you could do a similar exercise but appoint somebody else who's not a bank, and you could structure it differently. So it's all dependent on the advice that you get from professionals. So I think we can leave it at that.
Yeah, I agree with Thato. We have to be diplomatic. We're on a public platform. We can't say yes or no. True. We've got banks out there. We don't want to be sued. True. Thank you.
True. Imagine now your bank kicks you out and they're like, oh, thank you so much. You've been a great customer. A great client, but we're going to have to let you go. All right. So Umfundisi just texted that he's given access to all the participants to mute and unmute themselves. However, before they unmute themselves, should they have a question, they should raise their hand and I will note them. For now, those are all the questions. Apparently I missed a question, so I'm waiting for the participant to rewrite the question so that I can, oh, here it is. Okay, it says, is there any merit in having more than one guardian lined up? Is there any merit in having more than one guardian lined up?
Okay.
No, or should I go?
Go for it, and then I'm going to supplement if need be.
No, it's fine. So I'm assuming they're asking if this merits your point more than one guardian.
Yeah.
That's the question, right?
Yeah.
So there usually, I mean, that would be the preferred route to say that if you appoint a guardian over your minor child or children, you can appoint somebody, and in the event that that somebody that you have appointed dies, then you can appoint another person so that you have some sort of certainty. So you decide who you want to nominate as a guardian. You can have however number of people that you could nominate. But it's very important that you don't also try to create a confusion. It's very important that it's in sync and it's, you know, one succeeding the other. So I think that's what I want to emphasize from that.
I agree with Thato. It's very important that you appoint them in succession. Don't appoint two guardians to take care of your child at the same time. It's going to create chaos because who's going to have the other? Now you're going to have to go back to court. It's going to be an issue of, I want the child over a fortnight. Who's going to stay with the child full time? No, it must be in succession. The guardians must be appointed. And if you want 5, appoint them in succession, but don't have them, unless it's a married couple, then it's understandable. Then you can appoint that married couple, but everything must be orderly.
Yeah. Okay. Hey, these questions are coming. Okay. Oh yeah, the participant says, yeah, they meant in succession in the case of death.
Yes.
The question we just dealt with now. Okay, so the next one would be then advice on joint will versus separate wills when married in community of property, when one spouse isn't so disciplined. So I'm not sure because it doesn't sound like a question, but it says, I guess it's advice on joint will versus separate wills when married in community of property, when one spouse isn't so disciplined. I'm not sure what exactly is needed.
I think the person is requesting for advice on which option to choose.
The joint or the separate.
Yeah.
When spouse is
joint or separate, when your spouse is not disciplined financially or otherwise. Yeah. Thato, should I take that?
Yeah, I mean, like I said previously, so you will need to understand the pros and cons of having a joint will, and you need to understand what you're getting yourself into. And the only way for you to be able to appreciate and have full appreciation of that and the structure itself is if you seek legal advice and approaching a competent attorney or any other legal advice. And for that, what you're trying to understand is that you want to see to it that, you know, you would be in a position where you'd still have your freedom of gestation. Is that possible? Because now once you do it together, meaning you guys agree, you have to be in one mind basically to say that you can't.
Okay, Asanda, I'm guessing you know what he wanted to say.
He's back.
Thato, sorry, can you just give us also the last 30 seconds of what you're saying, or maybe 20? You can't.
This network issue. Yeah, this network issue is just affecting me.
It's not so bad, don't worry.
Yeah, I was saying there, you know, that's why we're saying people should approach an advisor so they could advise on what, you know, the pros and cons are and what structure would be able to work best. Appreciating that, you know, there might be some limitation because you might have a situation where spouse A says, let's give the house to Y, spouse B thinks X would be best placed. So you'd want to sort out those differences before and, you know, approach legal advice so that you see how best you guys can go about achieving that.
Okay.
And
Great.
Another tricky thing about joint wills is that you guys may agree whilst you both are alive that you want to give the house to Y, and then Dan passes away, right? Nandi is left. Nandi can go back and change the will and not give the house to Y anymore, and decide
that it can be sealed, can be a done deal to say.
Unless, but that's the thing, freedom of testation, and you can amend a will. There's no law in South Africa that says you cannot amend a will. You can amend a will. So when Dan dies, Nandi can go back and say, hey, by the way, I'm not happy with this will, you know, why is not going to benefit anymore. We had initially decided and agreed that Y was going to benefit, but now I'm not happy. I don't want Y to. So it's another limitation to your freedom of testation.
Sure.
So you really, like Thato said, you want to think about it. I know you love each other and everything looks honky-dory now, but when when someone dies, things, you know, things change.
Yeah.
And there's nothing wrong in one spouse exercising their freedom outside the other spouse, you know?
Yeah.
You don't have to be scared of your partner, your wife or your husband, if you don't leave a portion of your estate to him or her. It's you must go back to the purpose of this document. It is to take care of those who are dependent on you and make sure that if you pass, like your parents, for example, if you're taking care of your parents, if something happens to you, your wife or your husband might not do what you were doing. Maybe he might take care of them to a certain extent, but not the way that you would have. Yeah, exactly. So you want to also safeguard that. And there's nothing wrong with it.
Okay.
Yeah.
Okay. I really, I'm finding it very difficult to understand that, you know, there's no way whatsoever that can actually seal the deal to say, you know, so this freedom of testation, in as much as it's such a great, you know, law and rule, but again, it plays against me. Should I get married and I die, then my husband decides to change.
Yeah. Like there's always what ifs. What if this happens? So it's difficult to cater for all the what ifs, but to be on the side of caution, you must always examine your products and say, for example, the joint will versus a separate will, you know, who am I taking care of? Do I still have my parents? Do I still have my brother or my sister who is perhaps disabled, who cannot take care of themselves? What do I want to do about that? You and your partner might agree today that actually let's take care, you know, and you are actually taking care of this person. But when something happens to you, there's no guarantee that will continue, unfortunately.
Yeah, it's sad, but it is the law. It is what it is. Okay, so we've got 2 last questions before we close off, and Thato will be back shortly. Here he is. So I have 2 questions. These ones I'm directing separately or to each of you. So Thato, your question will be on the executor part. Are the beneficiaries allowed to change the testator's chosen executor recorded on the will? Are the beneficiaries allowed to change the testator's chosen executor recorded on the will? And then thereafter, Asanda, you will take, but also again, I'm sure you can feed into each other's comments and whatever information you're giving out. But then there's are the beneficiaries allowed? Oh no, that's what I read now. Where's it? Okay, do the beneficiaries' inheritance get taxed? And if yes, to what extent does it get taxed? So we have those 2 last questions, and then we close off for the conclusion. We get Mfundisi back for prayer and conclusion, then we're done.
Yeah. Okay, let's start with the first question, where beneficiaries would be of the view that the appointed or chosen executor is not fit, is not deemed competent, doesn't have the capacity, and whatever other ground that they may have. Well, with anything that happens, they may challenge that. I think there's leeway for that, but you need to have grounds that will justify you bringing a challenge. I mean, because try to also have, and I think the court will do a balancing act between preserving the freedom of testation by the testator and also hearing the grievance that may be brought forward by the beneficiaries, because you don't just say, I want somebody not to be appointed because I don't like the person. So the ground in the grounds to justify that.
Sorry for that. Can we please respectfully so just mind our unmute buttons as they give a little bit of distraction to our panelists. Thank you very much. Sorry, Thato, you may carry on.
Yeah, no, I think that was no confusion, unless if someone wants to do that.
Okay.
Nailed it.
Yes, Asanda.
Oh, you nailed it. There's nothing else to say.
Yeah, there's that one year tax.
Okay. I'll take the first one.
The beneficiary's inheritance get taxed, and if yes, to what extent does it get taxed?
Remember in the beginning when we dealt with the estate plan,
Yeah,
we spoke about making provision for tax as well. So that's one of the documents that you would have in your comprehensive estate plan. Yes, an estate does get taxed. And directive, so the directive, it depends on the percentage from time to time, and the threshold also depends. It varies depending on the time and the period when the estate is being administered. So the tax will be, depending on the directive, the government will take its money, and then whatever is left over then will be given to the beneficiaries.
Okay.
Yeah.
So, but there's a threshold. There's a threshold.
Threshold. Okay.
Yeah.
I remember you talking about if you have, like, the estate is 500 million or, yeah. So depending on that.
So the threshold, I think currently it's 3.5 million. If your assets are worth 3.5 million, above more than 3.5 million, then you will be taxed. There's a tax directive. It's 20% currently. So for example, I made the example of your assets being worth 5 million, then you will be taxed on the difference from the threshold, which is 1.5 million, 20% of 1.5 million. Then whatever is remaining then will be paid to the children or whoever is the dependent or beneficiary named in the will.
All right.
Yeah, I think maybe just to add there, I think it's very important that we distinguish between, I mean, the beneficiaries and the estate, because their tax will be, imposed on the estate. So it's not going to be to the beneficiaries directly, but it's going to be on the estate, and the residue will then trickle down.
Yeah.
Okay. Okay, awesome. Before we close, I think Umfundisi will cover this one. They are requesting for the exact name on YouTube, so the channel's name, where they can receive, where they can have access to this recording and the first session. So Umfundisi, I'll just ask him to mention the YouTube channel's name, and it will be on Facebook tomorrow for those who just need to recap. And if you need to share this with any of your family members, your friends, this will be on the TOC, Seventh-day Adventist Facebook channel. And then lastly, someone has asked for the two of you, while they're asking, are you also part of the attorneys? I know you're not attorneys, but are you part of that circle of people or the group of attorneys and organizations that are giving free legal advice in the week of the will? First question. And then secondly, they're asking that, I know Asanda did mention it's Uguti website. What's the name of the website? Not sure, but we can get that information, maybe put it on Facebook, but that's the information they're asking for also. In this week, which specific, if not specific, I know legal advisors are not allowed to give names to say, okay, you can go to these attorneys or you can go to these, because in the law it's not allowed, but which, I guess when you give the information of the website, then that's where they will see, right? They will see all the attorneys that are within the group that is going to help. So that's what we need. In Fundis, I just need the name of the YouTube channel and when this session will be posted tomorrow. And then from Asanda and Thato, if they are included in the people that will be helping this week on the wills, the week of the wills.
Okay, can I just take the second one, the website one? Thato will deal with the other one. The website one is the Law Society of South Africa. So it's small L, Law SSA, right?
Let me write it down. Sorry, can you just?
Yeah, it's www.l law.
Capital L.
Small L.
Small
s again. So it's Law Society of South Africa.org.za.
Is that Law Society a full word? Law Society.
No. So it's tsa.org.za. Yeah.
.org.
And then there you're going to have, they have on, when you open the website, it's going to give you all the different provinces in South Africa. Under each province, it's broken down into towns. You have all sorts of towns, from Vanderbilt to Johannesburg, you name it. They are all there. Under each town, there's a list of law firms, addresses, contact details. Everybody is there who is participating. It's a lot. It's a lot. Don't worry. You won't
They won't get lost. They can go to any town. They will be helped. Thato, you want to cover whether your fees are going to go on zero this week?
I think Asanda, put it nicely, directed the people to the website. Unfortunately, I'm not participating. I'm still working from home. I'm not interacting with anybody at the moment. So I think, they'll be best placed to visit the website, and they'll be providing assistance that they need. Yeah, because you need to have a consultation. You need to sit with that. Okay. And unfortunately, I'm not taking part, at least not this year.
Yeah, so that is the answer to the participant that asked. Advocate Asanda will not be part of this, and I'll call him Advocate Thato Mashishi will also not be part. I know you're not.
From being an attorney to being an advocate.
Yes, you're going to get there. I know. So I'd like to just close it before Mfundisi closes it formally. Thank you very much, Asanda. Thank you very much, Thato. Thank you, Mfundisi, for the opportunity. You two have been amazing. And I hope that God blesses you in your careers and your industries to help more and more people and to give them more information as you did today. Thank you to all our participants. Happy Sabbath. I hope that you had a great session, and may God bless you. Mfundisi, right to you.
All right. Thank you so much to everybody that participated. One of the questions that a person asked, Kuti, how does this program relate to stewardship?
Okay.
Remember, it's a holistic, stewardship is holistic in nature. We need to take care of ourselves in all life stages, from singleness, when I'm married, and when I get my kids, when I get my grandchildren, and what happens when I die. That we need to be able to manage our lives and manage our affairs in a holistic manner. So that's why we, as a church, promoted to be able to say, you need to be a good steward, not only when you're on earth. Do not leave your children with debts that they will have to pay by themselves. Do not leave them destitute, where they do not know after the father or the mother has died, where will they stay? They need to know that they are well taken care of. And that's why it's part of the message that we need to be able to prepare ourselves as stewards of God, and the other part that Unikiwe and the father also touched on was on the element that spoke about how then does it relate with the church, with your bequest, and through your wills as you do them, you are able to leave an offering to the church, to be saying to the church, listen, use this portion of my money that has stayed behind because of my death. Use it for evangelism. Use it to establish clinics, or use them to further the gospel through, whether through education centers, where the conference will then take that money, prioritize it according to the needs of the people who have written what they've said the money must do. That's why it is important that we're doing this. For these programs, we are laying a strong foundation. When God has allowed it, we want to, as a conference, to come to a point where we run a full trust services, where we'll also be able to keep the wills of our members and be able to assist them, so that when they die, they die in peace, and they know that their children will be taken care of. That's what other conferences, other unions are also doing. That's what we want to do. And lastly, we thank all of you. We thank all of you for participating. We thank you for participating and being with us. We'll continue trying to interact with these programs. May God truly bless us. To our young people, you can see that we did not use very old people. We tried to find the fresher ones who are out from school, who are also in the corporate world to come and serve the church with their skills, with their competencies and abilities to advance the message of God that Jesus cares. And that is our wish to all our young people who are listening to us, that come, work with us, work for the church. Do not only be a critic on Facebook, do not be a critic on social media. Use your skills, use what God has given you to advance and better the church in what it's doing. Thank you for all participating. The Zoom has been recorded. We are going to be able to find it on the Trans Orange Conference of the Seventh-day Adventists. It will be both on the YouTube channel, the Trans Orange Conference of the Seventh-day Adventist Church. It will be on the YouTube channel, and it will also be on the TOC Facebook page, which is also the Trans Orange Conference of the Seventh-day Adventist Church. May God bless you, and thank you for all participating. Amen.
Amen.
I will just then ask that we close our eyes and then we pray together again. God our Father, thank you so much for being with us this afternoon, where we explored a topic, where we are learning, Lord, how to take care of our lives before we even die. We pray for our members that you take good care of them and you assist them, Lord, in their plans as we continue, Lord, celebrating the Sabbath, as we also continue to be coming to a closure of the Sabbath, Lord. May we bask in your presence. May you be our hope and may be our strength. In Jesus we pray. Amen. Thank you.
Amen.
Thank you so much to the participants. Thank you to everybody that came. May God bless you and may God be with you. Amen.
Amen.
Thank you, everyone.
People can have their videos on so we can see you. Can we all see you? Before you leave. Thank you so much.
Thank you.
Travis.
Bye.
Bye.
Bye-bye.
Thank you very much for joining. All right. Is everyone gone?
Hey guys, thanks a lot. Hey, thanks, Thato.
Bye.
Thanks, Asanda. Okay,
Thank you.
Thanks, Manini.
Manini, thank
God
you.
bless you guys.
Thank you.
Thank you, Program Director Manini.
Lord.
Thank you.
Thank you very much.
Zap,
Have a
zap,
good
I'm
one.
closing it off now, hey?
Okay. Bye.
God bless.